Uber's arbitration rule is losing its grip, and Uber is losing control of the narrative. Hey everyone, this is Kevin the Apptrepreneur. Welcome to my channel. If this is your first time here and happen to really like this video, please do me a favor. Hit that subscribe button and ring that bell notification. We upload videos on a daily basis. Editorials, news, commentary, rants, interviews, live streams, premieres, all that jazz. And you will want to be notified of when those videos go up. So, we are talking about Uber's arbitration clause again. Now, quick summary. I always have to do this just in case you're new, but I'll be quick. Uber, whenever you sign up, whether as a passenger or a driver, you sign in their agreement that if there is a problem, you cannot sue the company. By the way, Lyft, Postmates, they all do this, but we're focusing on Uber today. Instead, you have to go to arbitration to settle the matter. Arbitration is a legal thing where companies basically hide behind arbitration because they know they did something wrong and they want to not get caught. The people who run the arbitration are hired by Uber, they work for Uber, and they are most likely going to side with Uber. There might be an occasion or two where they will side with the driver or the passenger. It doesn't happen often, and I assume it doesn't happen often because I have never actually read a story that someone, a driver or a passenger, took Uber, Lyft, Postmates to court, had the case sent to arbitration, and walked out saying, hey, you know, my problem actually got solved. You know what headline I've also never read? I've never read the headline that Jay Leno was always looking for when he was doing his headline segment, and that headline was, Psychic Wins the Lottery. At some point, you realize some things just ain't gonna happen, which means there's probably a fundamental lie behind the promise of what you are being told. However, interestingly, the arbitration thing has been challenged multiple times, and this woman has been given the gold standard, the golden ticket, if you will, of how to screw Uber with their own arbitration clause. And that is, basically, in a nutshell, although there's a lot of nuance to this, so don't go away after I tell you this, the judge basically said that she is not bound by arbitration even though she signed the arbitration agreement, like the terms of service. So, even though she signed the terms of service, she's not bound by arbitration. And you're going to love the reason why. So, let's go down here. Sitting in the back of an Uber in March 2018, Kemanosh was more than halfway home on a 4-mile trip from Columbus Boulevard to her Center City apartment when the driver of the 2010 Toyota Highlander ran a red light at 16th and Vine Streets, crashing into another vehicle. Suffering a fracture to her spine, concussion, and traumatic brain injury, Kemanosh sued Uber, its local subsidiaries, and the driver, requesting a jury to determine her payout. And a jury should determine her payout. That is a driver being reckless. He is speeding past a red light, and she now has these damages. Sorry, my nose is itchy, but I don't want to stop because this is really exciting. Traumatic brain injury. This is she totally deserves a compensation for this. But Uber argues in court documents by approving the rideshare's terms and conditions when she downloaded the app in 2013, Kemanosh had already forfeited her right to a jury, agreeing instead to resolve any legal disputes only through binding arbitration, which forces users to waive their rights to sue and settle matters privately. And as mentioned before, this does not work out for drivers or riders. I've never seen it happen. Hey, if you can find here's a challenge. Here's how confident I'm in this. If you can find a situation, and it has to be documented, it has to be a verifiable source. If you can find someone who went to arbitration and they were happy with the results, that Uber actually helped them out, hey, I'll give you $50 for that story because I don't think it exists. But anyway, our entire judicial system is found by trial by jury. Here's the thing. So there's all that. But here's where a wrench was thrown in the plan. Because a judge disagreed with Uber. strongly, and for very good reason. Because in a 19-page opinion this month, Philadelphia Common Pleas Judge Abe F. Fletman sided with Kemenosh, determining that because the app makes it possible to register for Uber services without clicking on a hyperlink to review the company's terms of service, the registration process did not properly communicate an offer to arbitrate under Pennsylvania law. Fascinating, right? Let's actually go to the beginning of the article, because I actually skipped the first part of this article because I didn't want to spoil the end game too soon. But when you download Uber's app, you agree that you're older than 18, that you're not using a stolen credit card to pay for your driver, and if you're like one Philadelphia woman and fracture your spine in a Center City car crash, that you won't seek a jury trial against a rideshare giant. But a Philadelphia Common Pleas Court judge has ruled that because Uber can't prove that Jillian Kemenosh actually read the company's terms and conditions before she signed up or rode in the car that ran a red light, she can't be forced to settle her claims behind closed doors. I love it. I love it. Granted, this creates a little bit of a kerfuffle. This sets a very interesting precedent, because terms of service are there to be agreed with. A lot of companies will not let you just agree to them anymore. They actually force you to scroll down to the end of to the bottom of the terms of service, click the I agree button box, and then click agree and confirm or something like that. They force you to do this, but there's really no way to tell that people are reading it. Most people are just scrolling to the bottom to basically start playing their game or something to that effect. My nose is really itchy right now, but I don't want to take a break. I'm sorry, folks. And here's what's really funny about this. Uber kind of does the same thing. They take it a little step further, because they say, hey, there's new terms of service. You have to agree to this, and you don't even have to read the terms of service. Just click, hey, agree, and you can start driving, you can start riding. You agreed to those terms of service, and guess what? You say we can do this, but a judge had a different opinion, because the way the app is set up, you actually don't have to read the ToS to agree to it. You don't. And the judge has now said that, hey, we have no way of knowing if she actually read it. She probably just pressed agree because she felt that was what was needed to happen to actually get to using the app. Unless you can prove that she read it, like you were there to verify that she read it, she can sue you. She can sue you, and by the way, she absolutely is. And of course, Uber and a lawyer for the company did not return requests for comment. Uber has until February 3rd to appeal Fletman's ruling. They will, by the way. Now, here's the interesting thing, and you can bet Uber will change this in the future. Had Kemenosh been required to click a link, check a box confirming she read and agreed to Uber's terms and conditions, or received email notice of the company's policies, Uber's arbitration-only rule would perhaps be valid, the judge wrote. So, that's pretty simple to implement. That is very simple to implement, and they will be implementing this. So keep an eye out for that. Keep an eye out. This is coming. And they will want to do that because they don't want to go before juries. They want to go to arbitration for reasons I listed earlier. In this matter, however, Uber took none of those steps, Fletman's opinion said. And, of course, this isn't the first time a question over Uber's arbitration clauses appeared for the court. I've actually talked about some of these stories. In 2018, after pressure from Senator Richard Blumenthal, I remember this story, and 14 women suing the company for sexual harassment by drivers, Uber lifted its arbitration agreement for riders or drivers pursuing legal action against a rideshare company for sexual misconduct. Also that year, a federal appeals court refused to endorse Uber's arbitration argument in a lawsuit brought by Boston area riders who accused the company of overcharging for rides to the airport. The panel determined that Uber's policy section failed to grab the user's attention, because it absolutely did. But in 2017, a federal judge bemoaned but backed the company's contract, sending a Connecticut man sue over illegal price surging into arbitration, writing, "This being the law, this judge must enforce it, even if it is based on nothing but factual and legal fictions." By the way, that Connecticut man, you never heard from him again. I bet you he did not get a good settlement. When it comes to requiring customers to approve a terms and conditions contract with an arbitration clause, Uber is not unusual, said Charles B. Casper, a Philadelphia-based consumer and class action defense lawyer who was not involved in the Uber case. The clause is typical of many cell phone, cable, television, and rental car contracts, Casper said. But whether Uber gives customers notice that they're forfeiting their right to a jury is a fair question. And I believe it is a fair question because I don't think they're being clear about it at all. Actually, the very fact that this keeps coming up, that we keep talking about this over and over again, I think goes to show how big of a problem this is. Uber deliberately hides this information, and they have been hiding it for years. And they will even hold you hostage. I mean, I know that technically all companies do this, but here's the thing. Uber is one of the few companies I can think of where it's like they'll say, hey, you're going to accept a lower rate. You're going to accept getting screwed. You're going to accept us making the prices for you, us taking as much as we want, more than 25% than promised, and you have to agree to it or you make no money. Go work at McDonald's. Some people accept it because, hey, they need a job right now. I think people are starting to wise up a little bit. That's why we have AB5, and that's why people are protesting. That's why there's going to be a Sacramento protest in like a couple weeks with Gig Workers United. But I think this is great that Uber was finally called on this by a judge who said, hey, no, this is wrong. You're not doing it this way. You are absolutely, no. You cannot prove she read this. You hid the ToS. You're going to go to trial. Now, Uber will settle. They will settle because they know that if this goes to trial, they will look really bad, and they do not want to look very bad. They want to get this behind them as soon as possible. They will make these changes so that this never happens again, and then we're going to have to find another way to call them on their BS. But anyway, that's where we're going to leave this, especially because my nose is just itchy. That's why there's so many cuts, because it's like I just couldn't be scratching my nose the whole time. But anyway, what do you folks think about this? Do you think good on the judge? Do you support this girl? Or do you think maybe Uber's getting a raw deal? Who knows? Maybe you're one of those people who feel like Uber shouldn't have to do this, that maybe they're getting screwed somehow. I'd love to know. Comment below, like, favorite, share, subscribe, and as always, flame responsibly. Have a good one.